Good morning, members. And I'm here with the other Senate minority members, Senator Edith and Ilong Guerrero and Senator Terry Santos. Good morning to the people of the CNMI. We come here today in the midst of the ongoing so-called impeachment trial of Governor Ralph Torres, an impeachment trial without a prosecutor from the House of Representatives. Since last Friday, the governor's attorney has been calling various witnesses, one of whom was not even on the witness list. The senators are supposed to ask the witnesses questions based on their testimony, some of which are totally not related to the impeachment article. This is a very difficult task for all of us, especially as minority members, if we want to conduct a fair, just, and impartial trial. Because one, there's no prosecutor to cross-examine the witnesses, and two, the Senate twice rejected the House impeachment records. The stack of photos, I believe, is up on the podium there that the Senate do not have access to. So today, as minority members of the Senate, Senator De Guerrero, Senator Santos, and I wrote a letter to the Senate President, who is the impeachment presiding officer, to inform him of our serious concerns with the Senate impeachment process. Please allow me to say that specifically addressed to our oath and duty as senators in a seat of great responsibility, not only to those who put us here, but also to our entire Commonwealth, that each and every one of us in the Senate have been given the opportunity to lead with integrity and follow the rule of law. The people have given us an opportunity, not a right, to sit in this very seat of honor and respect. Therefore, our loyalty belongs to the people, and we only serve in the public's best interest. If we have time later on, we can ask one of us will read the letter to the Senate President. In summary, we're here this morning in order to be better informed. We have requested the House members to meet with us today for an informational meeting, which is what this is today, and we respectfully appreciate your presence here. We are confident that this informational meeting will provide us a comprehensive and in-depth understanding of the impeachment case before us, as it is supposedly based on hard facts from you, the House members, who are not allowed to prosecute your own case. Si Zeus Masi.
Thank you, Senator Paul. Buenos días, Zantiro para todos hamzo ni manaiga guahu Sicilina papauta. Zagaigizo zani pumalo siya na mangatsongo para ben adinganyam zon roto paugnaugan. Sediha mon roto para ben impata informasyon ni timana anok ki Senate impeachment hearing. When rules are violated over and over, they change the rules or concoct them to accommodate their behavior, or a shift in standards occurs. What was once abnormal becomes normal in their minds. The governor's counsel, Anthony Uggan, not only mischaracterizes the facts, he distorts them to fit the governor's narrative. In violation of the basic principles of due process, counsel was permitted to testify on matters of fact in lieu of questioning witnesses and do so in the form of legal conclusions. In essence, the counsel for the defendant was allowed to be a witness and the defendant's counsel at the same time. As to the statements of Mr. Epifanio Cabrera Jr., his statements should be stricken from the record in its entirety, as it is purely speculative. Mr. Cabrera admits that after the draft travel regulations, their task force submitted to the Secretary of Finance, he never heard back from the Department of Finance whether the draft was subsequently adopted. When pressed further, he admitted that he doesn't know the status and whether it was eventually codified, distorting the facts. In reading travel documents, one must compare the reservations made at the time the travel authorization was prepared with the boarding pass together with the transportation costs on the travel authorization form. The proper questions to have asked of the witness would have been, did the governor make business class reservations on his and his spouse's travel? Did the boarding pass show that he and his spouse sat in premium class seats during their travels? And did the government pay for Governor Torres's and his spouse's first class and business class travels? The answer, based on overwhelming evidence, is clear and convincing. Yes, the government paid for the governor's and his spouse's premium class travel. Had the governor used his mileage to upgrade his seat, it would not have cost the government nearly $500,000 in travel expenses for himself and his spouse. As to Mr. Gary Camacho's testimony, the executive director of CUC, first and foremost, let's call a spade a spade. Let's call it a piggery, as documented in CUC official records, not a palapala, as the governor's council would like us to believe. Mr. Camacho stated that he was recently informed and that former Governor Juan N. Babauta had two official residences at the same time, whose utilities were being paid by the CNMI government. This statement uh, from Gary Camacho amounts to nothing but gossip. He neither verified nor brought evidence to prove his statement. His testimony should therefore be stricken from the official Senate records as hearsay. Defraud of utility and theft of utility. According to CUC Director Gary Camacho's testimony, theft is when you receive services and you do not pay for such services, or when there is a clear attempt to avoid any record of consumption. During the JGO hearings, Mr. Camacho, under penalty of perjury, stated that all adjustments and reverse entries made on Governor Torres's CUC accounts were made after a subpoena was served upon him on August 18, 2021. Subsequent to his September 27, 2021 testimony, a month-long computer blackout within CUC occurred, which purged all of the count histories on their system. Mr. Camacho emphatically states that there is no theft or fraud that occurred on Governor Torres's account, that every drop was on the meter, adding that everything was paid for. Of course, he would say that. There are many faces of fraud. The fraud occurred in the cover up after the fact. Sempre na huwalok na todza masakihonong pada elektrisidad sa ihafa mausa i-finance ha aposi todo. Tiene razón na husangan enno si Senyor Kamatsu. Manginatsa indukto za esta manadiretso todo i-account pues todza para tasodda gi CUC records pogo na ora zangyan man mamaysin it. Furthermore, Mr. Anthony Uggan's misinformation about the amount between Lieutenant Governor Palacios's and Governor Torres's average utility consumption is one for the math books. Mr. Uggan alluded that Lieutenant Governor's average usage of 800 to 900 per month is roughly 400 to 500 per person in his two-person household over a period of 1 month. Conveniently, Council Uggan distorts that Governor Torres's average for his 8-member household of roughly 277 from 2015 to 2019, or over a period of 4 years. To make an accurate consumption, here's the true picture. The true average of Governor Torres's 1 month utility bill of $16,949 divided by his 8-member household is roughly $2,100 per person over a period of 1 month. The testimony of Ms. Glenna Sakisa Palacios, she conveniently left out the fact that aside from attending the memorial mass for the late bishop, they attended a political gathering on the same day. The proper questions to have asked would have been, did Ms. Palacios and Governor Torres attend the Oregon political gathering? Did Governor Torres claim that trip? The answer to both is a clear and convincing yes. If the Senate were truly impartial, why was Ms. Glenna Palacios allowed to make legal conclusions that the governor's trip to attend the late bishop's memorial service in Oregon served a public purpose? But just a couple of months ago, Secretary Atalig, in sync with Governor Torres, claimed that Torres's travel to attend a funeral in Tinian was denied because it was a personal trip and did not serve a public purpose. As to the statements of Ms. Priscilla Jacopo from MBA, for $350 million in exposure, we got zero tourists. That is why there is no true financial gain for the CNMI and only to Mr. Robert Arrington, and a fully paid vacation for Governor Torres, his family, and their friends. Notwithstanding the presiding hearing officer's assertion that last Friday the Senate has consistently followed its own rules, he has in fact repeatedly and egregiously flouted them. To cite just a few representative examples, the presiding officer concocted a requirement with no basis in the rules for the senators to submit their questions in writing. The questioning of witnesses by senators is instead governed by Rule 24C, which provides that after completion of questioning by the parties, any senator present during desiring to question a witness may do so. Instead, what the Senate president did was flout this rule by denying senators their right to question witnesses in the absence of any objection by a party and act as a filter to prevent clarifying questions by senators to be answered by the witnesses. Counsel Uggan asserted that the House has chosen not to enter an appearance. That, as we now know, is not true. The behavior of certain senators in this purported trial was a complete farce and a travesty of justice that the Senate majority members and the governor's council who carried this out should be ashamed of their betrayal of trust, the public's trust. When the sun sets today, they do not have the votes to convict Governor Torres. And let me make it clear, that is not to be perceived as an acquittal. In closing, I'd like to share some wise words from Mahatma Gandhi. Remember that all through history there have been tyrants, and for a time they seemed invincible. But in the end, they always fall. Always. Thank you. Si Diyos masi dan hiliso.
Good morning, everyone. Hafa Day, Zantiro, Toto Marianas. My name is Representative Corina Magovnia, and I proudly represent Precinct 3. Let's be honest here. Who is at trial? Who really stands to gain? Who is trying to prove he is not guilty? It's not the Lieutenant Governor, the past or current Attorney General, or all other government employees, or even you Senate members here. Let us stay on track and not be fooled by the baseless propagandas and sleight of hand tricks by the impeached official's own attorney. The law is the law, period. Attorney Uggan's argument for Article 1 boils down to 3 points. Is it illegal for Governor Torres to use his private residence as an official government house pursuant to 1 CMC subsection 8221 through 8222? Yes. Did the governor illegally use the privileges granted under the same subsection to cover utility costs on 2 private residences at the same time? Absolutely. Were the privileges granted under the same law used to cover utility costs of an outside kitchen called the Palapala, which we all know is the commercial piggery, located on the governor's property in Esteo? Yes. Nowhere within the Commonwealth law states in clarity and convincingly that the government housing can be interpreted to mean private residence. None. Does it state privilege that a government housing can be more than one per named elected official? No. Does it state for the named elected official to choose any of his or her own private residence as a government housing? No. Council Agun used the word tradition when he was trying to explain that the payment of utilities for Governor Torres was acceptable. The problem with that is that tradition does not necessarily mean that it's the law. The problem with that is that it opens it up for enticing possibility for abuse of discretion, such as infinite meters or utility accounts, as reiterated by Executive Gary Camacho, CUC Executive Director Gary Camacho, when asked how many accounts can be opened under one name. Two, it can claim multiple residences or cause confusion of official government housing residents as a result of relocating. And three, abuse by having multiple dwellings and commercial piggery on property site. Going back to the second issue with Council Agun, did the governor illegally use the privileges granted under 1 CMC subsection 8221 through 8223 to cover utility costs on two private residences simultaneously? Yes, we have the evidence to prove to the people that the taxpayers did pay for utilities at two residences at the same time, and those documents will be shared with the public sometime today. Since it is the House prosecution's burden of proof, we will provide to the public the CUC billings proving that the governor was in fact using two residences simultaneously and claiming both residences to be paid by the taxpayers. In addition, nowhere does the Commonwealth law or laws show that the governor should receive the privilege of publicly paid for utility service. None. I challenge Attorney Agun and Director Camacho to show within what CNMI law does it say publicly paid for utility is included in the package deal. And the last issue was whether or not the privileges granted under subsection 8221 and 8222 used to cover utility costs of an outside kitchen, also called the Palapala. Again, we have the evidence to show as proof that the taxpayers pay for this utility, which we'll share later on this afternoon. The executive director of CUC, Gary Camacho, only verbally indicated that the $90,000 went back to finance or applied credit to other government agencies as finance requested. Verbal is not proof of such acts that it was in fact done. We have yet to see that document, so we are hoping that the executive director can provide the legislature with documents showing that the 90,000 was indeed credited to those government agencies as requested by finance. Also, according to Executive Director Camacho's testimony at the hearing and during JGO, both times he stated that Mr. Jack Torres's commercial piggery utilities was and still is billed as residential rate. This is illegal under CNMI laws and can be grounds for theft of utility of service, defrauding government services, and conspiracy to defraud a government agency, in agreement with Director Camacho to further a criminal enterprise. For Mr. Jack Torres, why was it converted to a residential rate and not a commercial rate, since it was a commercial piggery? In all matters under the eyes of the Commonwealth Code, using a private residence for an official government house is strictly prohibited and clear and convincing that when Torres used his sister's house in Coblerville and his home in Esteo, it is a fact that he had violated the CNMI laws. Based on these facts, it is clear that the governor clearly and convincingly violated the law under Article 1 of the impeachment. According to the Commonwealth Utility Corporation, Director Gary Camacho, during his JGO testimony, explained, and I will provide this at a later time, but here's a pyramid which shows what the rate sections are. Government being at the very top of the pyramid, which is the highest rate, then commercial, then residential. The governor's utility bills, the highest rate on the pyramid paid by the taxpayers, amounted to about $177,000 or $2,212.50 per month for a period of 80 months. The $2,212.50 per month of utilities used by household of six is significantly high and extremely unreasonable when Director of CUC Camacho testified under oath, clearly stated that the average household of roughly 15,000 ratepayers from Saipan, Tinian, and Rhoda pays between $700 to $800 per month of utilities. And he himself, Mr. Camacho, admitted such utility consumption of $177,000 is in fact a very much above average for an average household. To provide one comparison, Representative Ed Probst told us that his monthly utility bill for a household of six, similar to the governor, was only $400 per month when using responsible utility use management, and up to $600 on one occasion during an accidental overuse of utilities. The bottom line is, people, the governor should have knowingly known that he was violating the laws. He was a lawmaker himself, and even if he didn't, he had attorneys in his office to advise him. The finance department should have notified him. At the end of the day, he violated the laws, and he needs to pay those bills back. But the bottom line is, and I'm going off script right now, but the bottom line is he violated the law, and he needs to be held accountable and responsible for his actions. No one is above the law. Thank you.
Hafide and Tiro Tata Marianas. My name is Leila Staffler, representative of Precinct 5. My colleagues in the House have been diligent in their efforts to guard the CNMI purse from abuses and overspending. Despite the Senate's efforts to block the evidence collected and presented by the JGO over the course of the last year, the House will release documentation that supports each of the articles of impeachment for the public's review. To the public, you will be able to see this for yourself. Now, I worked on Article 2, which explored 4 counts of theft in violation of Title 6, Section 1601 of the Commonwealth Code. If we had been given the opportunity, we would have presented this evidence the JGO collected to show how this governor used his position to permanently deprive the CNMI of its meager local resources for his personal and political gain. From questionable reimbursements to having his staff coordinate so-called official travel that just so happened to coincide with political gatherings. Article 2 illustrates the methods in which this governor committed theft by creating a false impression as to the public purpose and true intentions of his official travel and reimbursements. To support these assertions, what you will find is the lack of follow-through on accountability practices that help facilitate these abuses of power. Providing a public purpose requires documentation to show that travel was conducted for a true reason. What you will not find in the hundreds of pages of this governor's travel are trip reports. This is one documentation practice that would have provided the public purpose of travel. But if there are no trip reports, one can only speculate. Provided with additional pieces of the puzzle, such as Facebook posts of political gatherings that happen to be during the same time frame as government travel, there is not much else to go for to show what reasons were for the governor to leave Saipan in the first place. For example, in Friday's farce of a trial, they tried to link the public purpose to one of the trips in Oregon and Alaska, as referenced in Article 2. Glenna Palacios claimed that one of the reasons of this trip was to attend the Bishop's Memorial and to meet with Gary Korobara. The Bishop's Memorial was never even written as part of the Governor Torres's TA documents. There is no evidence provided to even show that the governor participated in this event. This is an example of how this administration continues to create a false impression as to the public purpose and true intention of official travel. To the casual observer, it may seem incidental that there seems to be a political gathering at the same time as the Governor Torres' travel. But when you look at the balcony view of all travel conducted on the CNMI dime, you can see another pattern. Those incidental trips all support the governor's 2018 gubernatorial run. Sprinkled in between these spurious travel activities are multiple examples of theft where the governor received reimbursements for items like headsets, camping gear, hunting equipment, hotel rooms, and fuel for traveling to Rota by boat. We have seen the evidence and the testimony that proves this governor received multiple questionable reimbursements. Article 2 illustrates the methods in which this governor committed theft by creating a false impression as to the public purpose and true intentions of his official travel and reimbursements. Traveling without a public purpose is considered theft because it violates CMC Title 1, 8532, when an official uses their public position to obtain private and political benefit. That is a theft of public funds. It is also theft because it violates CMC Title 1, 8534. It is clear that each of the counts of Article 2 relates to the governor using public supplies, services, time, and personnel to support his gubernatorial campaign for 2018. Thus, he should be convicted for commission of theft. Thank you.
Senators, I think we are coming up to 9:45, and we recognize that you have the Senate trial resuming at 10 o'clock. I do have a closing statement, but we have a couple of minutes, I think, for questions, if you have any at this time.
I just want to add that the three of us had just signed a letter to the presiding officer. We are actually informing him that we are hereby temporarily recuse. We recuse ourselves temporarily because for the reasons stated in the letter. So we can probably proceed on. Hopefully, the president acknowledged already the letter, and we can be excused. So until such time, I guess we can continue to proceed. So, no, Malika.
Thank you, Senator. If we could also request a copy of that letter, we would appreciate that.
And Chair, likewise, if you can also produce us copies of your rebuttals after the presentation of this meeting.
Yes, I think we would be happy to do that for you. Good morning to the people of the Commonwealth. I'm Representative Tina Sablan. What you are about to witness today in the Senate chamber is the continuation of an ongoing betrayal of your trust. Governor Ralph Torres is supposed to be on trial in the Senate. He has been charged by the House of Representatives with 6 articles of impeachment for theft, corruption, and neglect of duty. The Senate has a solemn obligation to deliver due process and a fair trial. But what began last Friday and what continues today is not a trial at all. There are no prosecutors because the Senate leadership rejected the team of House prosecutors that the Speaker appointed. There is no evidence because the Senate leadership rejected the entire House impeachment record, all 8,000 pages and hours of video-recorded witness testimonies. The Senate is hearing only one side in this proceeding, the governor's, through his defense attorneys. The governor's attorneys say it is the House's burden to prove the impeachment charges. And that's true. But what is also true is that the House's hands have been unjustly tied by Senate rules that were drafted by the governor's council in collusion with the governor's allies in the Senate. This is not a trial. This is a travesty of justice. Because there are no prosecutors, there is no cross-examination of any of the governor's witnesses. There are no House objections to the procedural violations, no rebuttals to the misinformation presented by the defense. The senators themselves were deprived of their right under the rules to freely ask questions of the witnesses because the Senate president compelled them to put all their questions in writing to him and him alone. And then he screened their questions, censored some of them, and restricted follow-ups. Nothing in the Senate rules requires the senators to reduce all their questions to writing, but forcing them to do so anyway achieves the goal of frustrating any attempts by any senator to get to the truth. The governor's council, on the other hand, had no such restrictions. If the Senate had allowed the House to fully and fairly participate in the trial, with all the evidence we have to back each and every article of impeachment, they and you, the people we serve, would have had the opportunity to hear both sides. You would have had the opportunity to get to the truth. And here's the truth that the House would have presented had we been allowed. The law is very clear. Public funds shall not be used to pay for first-class travel for anyone, period. Did the governor travel first class on taxpayer dime? Yes, often, with his wife, at least 54 times between 2016 and 2019, according to the records. Did he break the law? Yes. Did he continue to fly first class at public expense, even after he was warned by multiple people to stop? Yes. Everything that the defense presented in Article 3, corruption, unlawful first-class travel, was mere distraction. Proposed regulations that purported to authorize first-class travel for the governor would not trump the law even if they were adopted. And raising accusations about other government officials who supposedly traveled first class too, without verifying that those first-class tickets were in fact paid by the government and not complimentary upgrades or paid out of pocket, is irresponsible and misleading. The governor's surprise witness, former AG Investigations Chief, Mr. Lawrence Pangilinan, testified that the Attorney General asked him to investigate the governor's travel in 2019. This ambush witness said he had opposed the AG's request. Why? Because Mr. Pangilinan said it was an investigation targeting one person. Let's stop to think about that. Most investigations, by their nature, are targeted. In 2019, documents showing the governor's lavish public expenditures, including unlawful first-class travel, began circulating widely. It caused a storm of public outrage. We in the House could not turn a blind eye, and we also began our own investigation of the governor in 2019. Governor Torres was a target of investigation because there was evidence that he broke the law and abused his office. The governor is also accused of multiple counts of theft: theft of utility services in Article 1 and theft of public funds in Article 2. Were this an actual fair Senate trial, House prosecutors would have questioned the mischaracterizations of the record by Mr. Gary Camacho of the Commonwealth Utilities Corporation. We would have presented to the Senate the actual billings for two of the governor's private residences, including the periods over a year and a half during which they overlapped. We would have shown the CUC memos confirming the governor's multiple accounts, including the metered account tied to the piggery on the governor's estate. We would have shown all the proof of payments by the governor, by the government, including the reimbursements that Governor Torres obtained for himself. We would have explained to the Senate the lack of any legal authority to permit the use of taxpayer funds for utilities at the private residences of the governor or any politician. We would have reminded them of the public purpose requirement for the use of public funds in our Constitution, in statute, and in finance regulations. We would have also reminded them that we actually tried, the House and the Senate, in the Budget Act that we passed, to explicitly prohibit the continued improper use of public funds to pay for the private utility expenses of elected officials. And the governor vetoed that. 4 counts of theft of public funds are listed in Article 2, and the governor's defense addressed none of them. Ms. Glenna Palacios, the former policy advisor to the governor, attested to the purported multiple public purposes at multiple stops during one of the governor's first-class trips in April of 2018. But had the House prosecutors been allowed, we would have asked Ms. Palacios specifically about the governor's campaign rally in Oregon. The governor did not claim in his travel authorization that he was making an extra stop in Oregon in order to meet with CNMI constituents for the memorial service that Ms. Palacios described. What Governor Torres claimed in his TA instead was that he was going to meet with unnamed potential business partners in Oregon. What he actually did instead was attend a campaign rally. Governor Torres had the government pay for his campaign stop through his airfare, stipend, and lodging. And it was for that campaign stop, which Ms. Palacios did not mention, that the House charged Governor Torres with theft of public funds. The defense totally skipped over 3 other counts of theft in Article 2. Had the House been allowed, we would have presented evidence that shows Governor Torres used public funds to pay for another campaign stop on Guam in June 2018. We would have also presented evidence that he claimed improper reimbursements for a trip to Rhoda that included lodging expenses for himself, despite having received per diem, lodging expenses for his spouse, who is not a government employee, and lodging expenses for a police officer who testified that he received his own per diem and paid for his own hotel room. And we would have shown evidence that Governor Torres fraudulently claimed reimbursement for fuel for a police boat when the Department of Public Safety has an open account at a different gas station, and there was no reason for the governor to pay out of pocket for this expense. And speaking of boats, the governor's defense counsel tried to play up the supposed billion-dollar exposure value of the governor's promotional boating expedition to the Northern Islands with his family and friends in the summer of 2020 in the middle of the COVID-19 pandemic. That particular trip appears in Article 5, Neglect of Duty, and is presented in the context of the more than 120 trips by plane and 85 trips by boat taken by the governor and his spouse at public expense, totaling more than $500,000 during times of severe crisis and hardship for the people of the Marianas. The House prosecutors would have presented documentation for all those trips that coincided with natural disasters, fiscal austerity, furloughs, and a global pandemic. The number of views from Mr. Robert Arrington's Deer Meat for Dinner videos is irrelevant. Article 5 is about the governor's negligence. Today, you will hear the governor's defense team present their case on Article 4 and Article 6. Article 4 contains 2 counts of corruption for misuse of government resources involving 1, the governor's unlawful and extravagant reimbursements totaling more than $78,000, and 2, his use of police resources for personal fishing or recreational boating trips. Had the House been allowed, we would have presented the receipts, the reimbursement requests, the DPS vessel usage reports, the boating logs, and the witness testimonies. Article 6, Neglect of Duty, deals with contempt of the legislature. The record is extensive, documenting the events leading up to the House holding the governor in contempt for failing to comply with the legislative subpoena, to the Speaker making the referral to the Attorney General, and the Attorney General ultimately pressing charges. It's all there in the House impeachment record that the Senate leadership has refused to see. Governor Torres's pattern of misconduct and the evidence justifying each and every article that would have been presented by the House prosecutors, whom the Senate has refused to allow. And there are many, many questions that should be asked of the governor's witnesses, and more witnesses who should be called. But the Senate leadership will not allow that either. Fellow citizens of the Commonwealth, this mockery of a trial will end soon enough. The verdict is already known. Truth and justice will not come from the Senate, but it may come through other means. Senator Paul Manglona and 2 other taxpayers have sued the Senate. The Attorney General has filed criminal charges against Governor Torres. Perhaps there's more to come. One thing is clear: our quest for justice and accountability will not end with the Senate.
Thank you, House of Reps, for giving us the opportunity to meet with you this morning on this informational meeting regarding the ongoing impeachment trial for Governor Torres. Obviously, we have a lot of concerns, and absent any prosecutors and absent any record of evidence, I do want to read out to the public a letter that we had submitted this morning, filed with the Senate clerk, and subsequently to be delivered to the Senate President, who is the presiding officer for the impeachment trial. And this is addressed to Honorable Jude U. Schneider, the Senate President and Senate Impeachment Presiding Officer, dated May 15, 2022, the letter. Dear Senator Schneider, as you know, there was filed on Wednesday, May 13, 2022, in the CNMI Superior Court, a civil action number 22-0097D, concurrently with a pending motion seeking an expedited, accelerated hearing date as mandated by the CNMI's Open Government Act at 1 CMC 9916B, followed the next day by a pending motion seeking a temporary restraining order, mandamus writ, and/or further relief. As you know, those court submissions were filed in response to understandings and perceptions by members of the CNMI general public, including the pro se plaintiffs, that prior Senate meetings and activities during which the Senate's current impeachment rules were purported to have been passed and adopted are invalid, null and void, and of no lawful effect, as the manner in which those rules were ostensibly drafted, adopted, enacted, enforced has been and remains contrary and violative of constitutional and statutory requisites, including but not limited to the CNMI's Open Government Act, mandates explicitly set forth at 1 CMC 9901 and such. Given that a CNMI Superior Court hearing ruling shall be imminently forthcoming as to these expedited, accelerated court motions, and the gravity and importance these matters have as to legislative and fiduciary duties, respecting the public and lawful interests of our CNMI community as a whole, we, your CNMI Senate colleagues, believe that it would be appropriate for the CNMI Senate to pause and hold in abeyance the ongoing CNMI Senate impeachment activities, including those convened and commenced on Friday, May 13, 2022, which are scheduled to continue this morning, unto such time as the CNMI Superior Court hears and rules on an expedited, accelerated timetable the pending motions requesting a temporary restraining order and other relief. In related and extremely pertinent aspect, and contrary to assertions that the CNMI Senate has consistently followed its own Senate rules and impeachment rules, the unfortunate facts is that CNMI Senate members have repeatedly and egregiously flouted, abridged, broken, and violated the rules on a multitude of occasions over the past months respecting CNMI Senate impeachment endeavors. Just a few of the events and circumstances exemplifying this fact include the following activities. 1. Rule 19 provides that any motion to dismiss must be submitted in writing to the presiding hearing officer within 14 calendar days prior to the day set for the commencement of the hearing on the articles of impeachment or as permitted by resolution adopted by the Senate. 2. The day set for commencement of the hearing was May 13, 2022. The window to file was therefore from April 29, 2022 to May 13, 2022. Counsel Ogden filed his motion on March 28, 2022, fully 32 days outside the window to file. No resolution was adopted to permit a motion filed outside the time window to be considered. The motion was therefore time barred and not properly before the Senate. 3. Rule 17B requires the parties to submit a list of witnesses and exhibits 10 days before the hearing, but the impeached officials' counsel has brought last-minute ambush witnesses before the court. If there is flexibility to allow for defense witnesses, this flexibility should also extend to Senate members to call witnesses too, including expert witnesses. 4. The Senate should be able to recall witnesses to rebut the testimony elicited by the defense. 5. Without a prosecutor to object to such evidentiary issues pursuant to Rule 16B, we senators, as triers of fact, are without the means to screen inappropriate evidence. I note, however, that Rule 16B3 provides that any senator may appeal evidentiary rulings by the presiding hearing officer, who must submit to the Senate without debate the question of whether this ruling will be sustained. 6. The presiding officer concocted a requirement with no basis in the rules for the senators to submit their questions in writing, Councilor Bermudez cited Rule 23B, which applies to procedural objections by parties, not to the questioning of witnesses by senators. The questioning of witnesses by senators is instead governed by Rule 24C, which provides that after completion of questioning by the parties, any senator present desiring to question a witness may do so. If a party objects to a senator's question, then the presiding hearing officer shall rule on the objection. 7, the presiding hearing officer flouted this rule by denying senators their right to question witnesses in the absence of any objection by a party. 8, the governor's defense attorney Ogden asserted that the House had chosen not to enter an appearance and chosen not to submit an impeachment record. Neither of these assertions is true. House members did in fact enter notices of appearance and did submit the impeachment record, and both were rejected by the presiding hearing officer on wholly spurious grounds. In violation of core principles of due process, defense counsel was permitted to testify himself on matters of fact in lieu of questioning witnesses and did so in the form of legal conclusions. 10, Rule 25A provides that all times while the Senate is sitting upon the hearing, the doors of the Senate and the Senate gallery shall be kept open. The doors were closed throughout the duration of the hearing in blatant violation of this rule. 11, Rule 43 provides that these impeachment rules may be suspended or amended by a record vote of a majority of the members of the Senate in the interest of justice. The rules may not be unilaterally suspended or amended by the presiding hearing officer. Any actions by which he purported to do so were ultra vires. 12, Senate Rule 44 is a catch-all provision, allows for the Senate to have the final say on any matters that include any of the issues identified by the members. The rules clearly allow for flexibility to address reasonable concerns. Based on the above described events, our people of the Commonwealth, activities and circumstances, we, your CNMI Senate, colleagues hereby respectfully request that the CNMI Senate pause and hold in abeyance the CNMI Senate's impeachment trial and related activities until the latter of the following two events transpires. 1, a time period of 48 hours from 10 a.m. on Monday, May 16th, which is today, 2022, or 2, the CNMI Superior Court hears and rules on the pending motions requesting a temporary restraining order, mandamus writ, and or further relief on an expedited, accelerated basis, which motions were filed May 13 and 14, 2022 in CNMI Superior Court Civil Action Number 220097D. Signed, myself, Edith De Leon Guerrero, Senator for Saipan, Senator Paul Manglona for Rota, and Senator Teresita Santos for Rota. Si Diyos mo si Toto Marianas ni Tempon Mizo.
I just want to add that, as I stated earlier, the three of us also submitted a letter to the presiding officer. This letter is with regards to our temporary recusal in the Senate proceedings. And Senator Santos, you want to read that letter that we all signed? Thank you.
Thank you, Senator Manglona. First, I would like to extend gratitude to our House counterpart here for listening to the rebuttals that were made relative to the articles of impeachment. And before I read this letter, I would again like to request if we can be provided copies of those presentation, if allowable. And so, to the Honorable Jude U. Hoff-Snyder, Senate President and Senate Impeachment Presiding Officer, 22nd Northern Marianas Commonwealth Legislature, Honorable Jesus P. Mafnas Memorial Building, Isa Drive, Capitol Hill, Saipan MP 96950. Dear Senator Hoff-Snyder, as you know, we transmitted earlier to you a 4-page letter respectfully requesting that the CNMI Senate pause and hold in abeyance the CNMI Senate's impeachment trial and related activities until the latter of the following two events transpires. First, a time period of 48 hours from 10 a.m. on Monday, May 15th, 2022. Or second, the CNMI Superior Court hears and rules on the pending motions requesting a temporary restraining order, mandamus writ, and or further relief on an expedited, accelerated basis, which motions were filed May 13 to 14, 2022 in the CNMI Superior Court Civil Action Number 220097D. Our understanding is that our request has not been and shall not be accepted and or granted, but rather has been denied and all shall be deemed to have been denied. Accordingly, and given the utmost urgent and existing exigent activities, events, and circumstances within and relating to the current CNMI Senate impeachment proceedings, we are compelled to recuse ourselves temporarily and now do hereby temporarily recuse ourselves from the CNMI Senate impeachment proceedings until such time as the CNMI Superior Court hears and rules on the pending motions requesting for a temporary restraining order, mandamus writ, and or further relief on an expedited, accelerated basis, which motions were filed May 13 to May 14, 2022 in the CNMI Superior Court Civil Action Number 220097D. Respectfully yours, Poe A. Manglonia, CNMI Senate Member, Edith E. De Longuerero, CNMI Senate Member, and myself, Teresita A. Santos, CNMI Senate Member.
I also would like to extend our appreciation, the Senate minority members, to our colleagues in the House. Those of you who made a presentation this morning, you have enlightened us, given us more information and a better and more comprehensive understanding of what you would have done had you been allowed to prosecute the case. We are put in a difficult position, having to conduct a fair and impartial hearing. Yet we do not have a prosecutor, and we do not even know if, in our line of questioning, we are acting as such. And so I know that. This is a very last minute call to sit down, and we, at the advice of the council, were informed that they are not a party to the impeachment hearing. It is proper to meet with you all. And so I hope this is not the last meeting we have to get a better understanding of the impeachment articles of impeachment that you have filed. And it's only our hope that this will be conducted in a fair manner for the people of the cinema, and we will probably be reaching out to you also for further information in the future. Can I ask at this point, can we be provided with a copy of all the impeachment records so that we can try our best to make a motion to offer so that it be accepted?
You most certainly can. We'll provide those. Thank you.
Okay. So, Senator, I'll go on recess for now.
We're good.
Is there anything else that you might want to add? I know that the Senate possibly will not entertain our a letter informing them that we are temporarily recusing ourselves. And I really don't know what is going to be their response to such a letter. But for us, or for myself, I feel that sitting in there, listening to a one-sided trial, is not providing to the people of the cinema something that's I guess worthy of our time to participate. It's as was mentioned, it's like a farce or a bogus trial, and so unless they they drag us in. I think our position is, they can conduct it. The question remains whether that hearing is properly convened because of quorum issue. They have four only, but I guess they can take the legal position that a quorum has been established since Friday. But we are concerned about that because more than 2 days had elapsed, and so they might need to establish a quorum. If not, then they probably will proceed with the remaining two articles, which is Article 4 and Article 6. Article 6 is the contempt. And so um, I guess we can recess for now, but I think nothing is stopping us from communicating with you, and we appreciate any information with regards to the pending two articles, as well as if we are successful in recalling some of the witnesses, the issues that you are raising. It's alarming because, as some of you have mentioned, you are witnesses that you're going to be calling. Can I ask how many witnesses do you think by the time you have prosecuted your case would have come up and be questioned? Are you talking about 20 witnesses, 30 witnesses instead of just the one or two per article?
If I may, as you may have observed from the JGO committee hearings, there were a pretty significant number of witnesses that were interviewed over the course of months of these hearings, and there would have been some interest, I think, in recalling some of those witnesses, and also calling in witnesses for whom subpoenas were approved, but who were not actually called in for questioning. And I think that the point that was earlier raised about just the inability of the House to provide cross-examination, that was a real injustice as well. For just to provide rebuttal and illuminate some of the misinformation or the omissions that we observed from the testimonies that we heard from the defense's witnesses. So I just want to say thank you as well, senators, for your commitment and standing your ground in defense of just fairness and due process in this whole proceeding. These are truly unprecedented times. I, as a member of the House, I think my colleagues who are able to make it today appreciate this opportunity to have this forum, at least to share what would have been presented if there was a fair trial. And our doors are open. Going forward over the next few days, however this unfolds, if you have other questions, if there's other information that we can share with you, you mentioned the impeachment record that we attempted to submit, please let us know. We're here to help.
So thank you, and we'll keep in touch, and hopefully hope for the best for the people of the cinema. Thank you again for your patience and understanding.
Thank you as well, senators.